After we have our last person who is online as soon as Andrea is able to turn on her camera. Mr. Riley, are you ready for me to go ahead and start the meeting?
Please, thank you.
Good morning. Notice of this meeting has been posted online for at least 72 hours. Members of the Commercial and Residential Boards of Adjustment may be attending virtually in compliance with the Texas Open Meetings Act. The staff present today are Beth Knight, Karen Moreno, Ashley Tolliver, Mary Wells, and Trey Qualls. Chair, will you please call the meeting to order?
I'd like to call the meeting of September the 18th, Commercial Board of Adjustment to order.
Thank you. We welcome everyone to the Board of Adjustment for Commercial Matters. This board is a citizen board appointed by the City Council. By state law, a minimum of 9 members or alternate members must be present to provide quorum in order to conduct business. Today, we have quorum with 10 members present. Today's meeting agenda can be found online at www.fortworthtexas.gov. Speaker registration forms for today's cases on today's agenda were required to be turned in prior to the start of this meeting. Today's public hearing will be documented by YouTube this morning and video conference recording, which will be available on the city's website later. To achieve a timely and orderly meeting, the Board of Adjustment requests the following rules of procedure be respected. When not speaking, online participants are required to be muted to avoid any potential background noise which may distract from a hearing. Each case will be called in the sequence listed on the agenda unless otherwise directed by the chair. Staff will summarize the cases based on each request. As your case is being called, ensure that you are in front of your camera or on your phone and be prepared to speak. If you are here in person, please immediately step up to the lectern in front of the board. If you are not the applicant but will be speaking in favor or in opposition, please wait in the front rows and be ready when it is your time to speak to minimize delays. Remember, if you are online, please remain muted until it is your time to speak. All speakers must remember that all dialogue must be directed to the Board of Adjustment only. For the online speakers, unless you are reading from a document, please look directly at your camera. A total of 7 minutes is allowed for everyone speaking in favor and 7 minutes for the opposition. If there is more than one speaker present today for each case, they should have gotten together with other like-minded speakers to determine how much time each speaker will have. If necessary, a few extra seconds may be allowed to ensure the speaker's final point is made. To start, I will ask the applicant to present the facts of their request and the reasons they believe the board should approve their request. We will then ask for other persons in favor of the application to speak to present their information. When the applicant and others in favor complete their presentation, we will ask those opposed to make their presentation with their 7 minutes. The applicant will then be allowed 3 additional minutes to address any issues presented by the opposition. In 2019, there was a rule change regarding translation cases. When speakers require the services of a translator, all speaker times during those cases will be doubled. After everyone has spoken, the chair will ask the board if they have any questions for any of the speakers. There is no time limit during this period. If necessary, a closed executive session may be held with respect to the posted agenda items to enable the Board of Adjustment to receive advice from legal staff. After the question period, the public hearing will be closed and members of the board will be asked for discussion or motion on the application. Once a motion is made and seconded, then they will call for a vote. For this hybrid meeting format, voting by the board will require a voice vote from each member, or if online and their audio is out, raising a hand in favor or in opposition to a motion. If an application is denied, an applicant will have 10 days in which to appeal to a court of appropriate jurisdiction. For more information on this process or additional information on any case on today's agenda, you may contact the Board of Adjustment at 817-392-8026 after this meeting as early as tomorrow morning. At this time, please mute your microphones if online, and everyone should turn off the audible alarms on your electronic devices so we will not be distracted during our meeting. I ask board members to remember to keep your microphones muted unless you are speaking. If you raise a digital hand on the screen to request to speak, once you are called upon and finish speaking, please make sure that the digital hand is turned off. Thank you. The first order of business is the approval of the minutes of the August meeting, and we are open for a motion to approve.
Make a motion to approve.
I second the motion.
Motion made, seconded. Roll call, please.
Yes. Mr. Lindsay, your vote, please, sir.
Yes.
Thank you. Mr. Perez, your vote, please, sir.
Abstain?
Thank you. Mr. Riley, your vote, please, sir.
Abstain?
Thank you. Mr. Hook, your vote, please, sir.
Yes.
Thank you. Mr. Wilson, your vote, please, sir.
Yes.
Thank you. Mr. Hoppy, your vote, please, sir.
Approve.
Thank you. Ms. Duffy, your vote, please, ma'am.
Approve?
Thank you. Ms. Shields, your vote, please, ma'am. Ms. Shields, your vote on the minutes, please.
Approve.
Thank you. Ms. Murillo, your vote, please, ma'am.
Approve.
Thank you. The motion passes with 8 affirmatives and 2 abstentions. Chair, are you ready for the first case to be called?
BAC 24026, staff presentation.
Case BAC 24-026, address 3439 Alta Mesa Boulevard, owner 539 Moore Street, LLC by Watermill Express. The zoning is currently E Neighborhood Commercial and FR General Commercial Restricted Districts. The applicant is requesting a special exception to permit the construction of a water and ice vending kiosk, and is requesting a variance to permit a water and ice vending kiosk in a location that is not allowed. The required location is behind the front wall of the primary structure furthest from the street, and the requested location is in front of the front wall of the primary structure closest to the street.
Thank you. So we are doing things a little bit different for everybody. In case you weren't here last month, we are doing the work session essentially right before the public meeting, and so we're doing it all kind of together in one room. This site is primarily zoned E, neighborhood commercial. There is one spot here in the middle that is zoned FR. But the other thing to notice here is that the site is more than 250 feet away from residential in either direction, or single-family residential in either direction. And so what that means is that this site is not subject to the parking requirements. So the standard that you see listed in the staff report of the kiosk has to meet the parking requirements. There are no parking requirements here to worry about. So what we see here is that this site is an L-shaped building that is here in the middle of a U-shaped lot that is primarily in the middle of a lot of commercial at the intersection of McCart and Alta Mesa. The applicants are requesting to put the water kiosk here, essentially in this area. Let me try that again. They're asking to put it here, so it's closer to the monument sign. And when they do that, what happens is it is in front of this front building wall here, whereas the requirement says that it has to be behind the building wall that is furthest from the street, which would put it back here. Here, because this is the building wall furthest from the street. The tricky part on this lot is that in order to do that, the building would actually have to be here because this is a property line. So in order for it to be on site, it would have to be either here or, no, I'm sorry, it couldn't be there. It would have to be here is where the ordinance requires it to be. But there is space for them to put it anywhere here so that it would at least be behind the front wall of the wall closest to the street. And all kiosks that are self-vending are required to have a special exception. This one is proposed to go essentially here. As you can see, that there is minimal landscaping on the commercial lot. The applicant's site plan shows that there is if you zoomed in, here, and I don't think that we can here, that there is a little bit of space around the, on the northeast and south sides of the 2 parking spaces that they're taking up, that they could have added landscaping. That's not being proposed. They are proposed to merely put this structure in the middle of the parking lot. One of the things that we found last week is that the water department looked at this and said, hey guys, all of the multi-tenant buildings here have sucked up all of the allowed water meters that are on the lot. So you can't just tie into the water meters that are servicing this building. So they are having to, I don't know if they thought that they were going to be able to get service from the Jack in the Box and come over, but you can't cross property lines with utilities. So they're having to figure out Plan B, which may be tapping into this water main that's up here and coming down. But all of that is significantly more work than they were anticipating, which is why you see in the late correspondence that they are asking for a continuance for 3 months so that they can get this figured out, so that they can decide if this is a project that they want to move forward with or not. But it's on the agenda, so we need to have something happen with it. What questions do y'all have?
So I guess they don't own that neighboring property. It looks like the building just continues over there to the
West?
west.
That is correct. That is a separate property owner.
Yeah, separate property. Go ahead.
No, so, you know, because of that and some of the other issues, they may look at a completely different lot for this to be placed on. So I think that's one of the other things that they're going to have to look at. Did you have another comment, sir?
Well, the regulations that were given, one talked about non-habitable accessory use. And one talked about a recycling collection facility.
Yes, there is an administrative interpretation that says that because these are unattended structures that essentially exchange money for goods that are unattended, that tend to be out in the middle of the parking lot, this is the closest related use that we have, and so we are going to treat them under that same land use heading that's in our ordinance.
So there's no specific section for unmanned vending machines or?
No.
Because these do exist elsewhere in the city, these water.
Yes,
Distribution
there
places.
are several off of Hemp Hill
Right.
that have been approved over the last few years. There are some, I know, off of East Lancaster and I think it was 25th Street, Northeast 25th Street.
Yeah,
Yeah,
that was my only.
I also had questions about what is the definition of an accessory structure, because this is a business.
It is a business, but
And we're going to have more businesses that are unattended in the very near future. And what's a Chick-fil-A kiosk count as?
I don't know that we've seen a Chick-fil-A kiosk yet.
Over in Montgomery Plaza parking lot.
Okay, well, it sounds like it is time for us to update our zoning ordinance definition then. Yes, sir.
As far as landscape, is that something that we can require as far as, okay?
Yes, that is listed at the top of the staff report, where that in section 5.100, that you can add additional conditions on this if you think that it would make it more compatible with the neighborhood. And I don't see any questions from our online folks. Oh, I'm sorry, Mr. Wilson did have one. Yes, sir. Oh, okay. All right.
And we have a request for continuance, 3 months, correct?
Yes, sir.
No other anybody else has signed up for this.
Karen, has anybody else signed up to speak for this? Okay. We told the applicants that they should have been here also, but I guess we can't, if there are no other questions, then we can move on to the public hearing portion of this.
I'd open the public hearing. Is there anybody here in support of this application? Seeing none, hearing none. Is there anybody here in opposition? I will close the public hearing portion, open it up for comments or questions of the board, and that acknowledge that we have received a request for a continuance of 3 months. Seeing none, so is there a motion?
We grant them a continuance for 3 months.
Okay.
Second.
Mr. Hoppy, roll call, please.
Yes, Mr. Perez, your vote, please, sir. We didn't catch that.
Thumbs up?
Yes, okay. Ms. Reed, your vote, please, ma'am.
Approve.
Thank you. Mr. Riley, your vote, please, sir.
Approve.
Thank you. Mr. Hook, your vote, please, sir.
Approve.
Thank you. Mr. Wilson, your vote, please, sir.
Approve.
Thank you. Mr. Hoppy, your vote, please, sir.
Approve.
Thank you. Ms. Duffy, your vote, please, ma'am. Thank you. Ms. Shields, your vote, please, ma'am.
Approve.
Thank you. Ms. Murillo, your vote, please, ma'am.
Approve.
Thank you. And Mr. Lindsay, your vote, please, sir.
Yes.
Thank you. That motion passes unanimously, 10-0.
Vote, but it still passes as now.
It was my understanding that as long as he had video,
No, that's not correct. The statute requires both audio and video to be working for someone to count as quorum or therefore as a vote. So if he can get his audio, we'll count the vote and it'll be 10-0.
If you're
Otherwise,
talking my audio should be a now on, so I
There
vote
we go.
yes for
okay,
continuance.
great, thank you. Okay, we'll go back to the 10-0 vote for that, please.
Yes.
Does he not
Please.
need to vote now? Since
He
we
did.
can, oh, did he? Okay.
Case number BAC-24-027. Address, the property subject is located at 8601 Harmon Road. The property owner is Harmon Squared SEI LLC, and the request is presented by Priority Signs and Graphics on behalf of the owner. The current zoning is F for General Commercial District, and the request is for an special exception to permit an electronic changeable copy on a monument sign along the southern property line.
Yes, so this is a continuation of a case that you saw a few months ago. The F, general commercial zoning, follows here. It is surrounded by industrial zoning here, and this PD is for industrial zoning also. So the applicant's requesting a sign this time that would be here on the southern property line to take advantage of this part of Harmon Road. As such, it does not face residential, and so they are asking for, so it would be approximately here, right behind where that white pickup is. And so they are asking for a monument sign with electronic changeable copy that meets the best of our regulations. And so because of that, the staff is deemed that it is compatible with the neighborhood. And so the other sign on the eastern side was approved. This one was approved last month, but they did not have their building permit their sign permit turned in for both signs at the same time, so we've had to separate their public hearings. What questions do you have on this?
None at this time that I see. Guess it would be appropriate to open the hearing.
Yes.
Is there anybody here to speak in support of this case? Anybody online?
She had indicated that she was going to be online. Okay, she is online but muted. Ms. Lemus, if you can go ahead and speak to the board, please, regarding this case?
Yes, this is just the standard 7 sign, and asking to add the standard changeable copy for the sign pricers. As previously mentioned, we didn't submit the second monument sign along with the previous public hearing, so we had to do 2 separate ones.
Is there any other one speaking speaking in support?
I'm sorry, it was breaking up.
Is there anybody else here to speak in support?
And Angie, that question is for us, and we do not have anyone, sir.
Anybody here to speak in opposition?
We have none.
Does any of the board members have questions of the applicant? I see none. I'll close the public hearing and ask for discussion and/or a motion by the board.
I have a question. Is it pretty typical to have 2 monument signs on a hard corner?
Karen, can you go? Oh, thank you. You had already pulled up their site plan. So they are allowed 2 monument signs if the spacing between them is at least 100 feet apart. And so I think that's one of the reasons why you do see this type of business pick the corner, is so that they can try to have 2 signs, 1 on each street frontage.
Now you have I guess another question is of staff, the separation, plus they have the necessary frontage to justify these costs or justify both signs. And then also the only thing we're voting on here today is an electronic changeable copy.
Yes, sir. They do have to meet the regulations for the allowed sign square footage based on their street frontage. So if they didn't meet that, we would not be able to bring them forward, because electronic changeable copy signs are not allowed to have any variances for size, height, or width with them.
Any other questions, James, or anybody else?
I have a question.
Tony?
Thank you. This is actually across the street from my neighborhood. So my question is, across the street on Harmon, on the 7-Eleven side, there is a residential community to the west. What's the distance requirements from this kind of sign to a residential neighborhood?
So the distance to residential is typically based on the size of the electronic changeable copy size itself. And so the extra ambient light that is anticipated to come off of this is 26 feet. And the subdivision to the south is more than 320 feet away.
And I'll vouch for that. That is correct. And there's enough foliage and growth and enough of a buffer that it shouldn't impact that residential area. Based on that requirement.
Any other questions? Did not ask for a motion.
I move for approval BAC 24-027.
Second?
Mr. Hoppy made the motion, James made the second. Roll call vote, please.
Just
Yes.
before we vote, I show the number is 024.
that may have been their previous case number, because it is actually 027.
Okay.
So the consideration of motion applies to BAC 24027.
Yes, that's correct.
Roll call, please.
Yes, Ms. Freed, your vote, please, ma'am.
Approve.
Thank you. Mr. Riley, your vote, please, sir.
Approve.
Thank you. Mr. Hook, your vote, please, sir.
Approve.
Thank you. Mr. Wilson, your vote, please, sir.
Approve.
Thank you. Mr. Hoppy, your vote, please, sir.
Approve.
Thank you. Ms. Duffy, your vote, please, ma'am.
Approve.
Thank you. Ms. Shields, your vote, please, ma'am.
Approve.
Thank you. Ms. Murillo, your vote, please, ma'am.
Approve.
Thank you. Mr. Lindsay, your vote, please, sir.
Approve.
Thank you. And Mr. Perez, your vote, please, sir.
Approve.
Thank you. That motion passes unanimously, 10-0. And then before we close the public hearing, the last item on our agenda is the discussion for the current board hearing format. Ms. Stringfellow, did you want to make any comments on this, or do you want to have the board ask questions and discussion first?
Yes. The reason why we wanted to give a few comments, I wasn't sure I was going to be doing this today, but happy to answer any questions that you all may have had as to the reason why we did the format. So one of the things that we should have done is we had the discussion with the board chair, but we didn't really get into the specifics with you, the members. And so our apologies for not doing that. So we had some discussions with the city attorney, as well as I had observed a couple of meetings. And so one of the things that we wanted to bring to the board was more consistency in terms of our meeting start times, because we feel like that's necessary for you, the board members, but then also necessary for the public, so that we're consistent with those start times. And sometimes having the work session and then having the meeting at a different time kind of hurts us with doing that, because sometimes we're trying to anticipate how long we need the work session to be, and then how long we need the meeting to be. And then we also, keep in mind, have the residential board that meets later. And so after some discussions with the city attorney, one of the things that was even brought up is sometimes during the work session, what happens is there are things that are brought up during the work session that we can't use during the hearing because it's technically not the hearing. And so we're having to rehash things in the hearing that were done in the work session. And so bringing my experience from other cities, I thought that it would be best to try this format whereby we did the presentations, had the discussions and everything during the hearing. And so we're not having to bring things up twice. And then also there's not a question from the public as to whether or not, what's happening during the work session versus happening during the public hearing. Now, I realize there are some other boards and commissions, for example, Zoning Commission, where they still have work sessions, but they're not quasi-judicial. So you're special in that respect, and that you're the only one that is quasi-judicial. So your decisions cannot be appealed to anyone but a court. So that's why I felt like it was necessary to have all of this happen within the hearing. So I'm happy to, entertain any questions. Also, we wanted to do this on a trial basis. We at least wanted to give it 3 meetings. So if it was a disaster, we were willing to, see what we needed to change. But that's the reason why we went to this format, and my apologies for not sharing that with the entire board beforehand.
Any comments or questions of the board?
I just have a comment, really. So from, well, here's my question. So from now on, it's 10 o'clock? We're going to start at 10?
Yes, and
Just to establish that
I'm going to
consistency.
actually, so one thing that I've talked with the staff about is I just want a consistent time. And I would leave that to the board members as well as the staff, you know, whether or not that time needs to be 10, whether or not that needs to be 9. But I do think it's important, you know, for you all as well as the public to have a consistent start time for this group.
But staff will still have the flexibility to have it at 9 o'clock if the docket's fairly full.
That would be the only time that we would move it forward is if if we had probably 5 or more cases, and that were particularly complicated, then we would look at allowing the board more time to make sure that all of the applicants got their positions stated.
And my only comment is, I think it'd be great if this is coordinated with all the other commissions, like you said, to make the public used to, you know, how meetings are held. I think that the Building Standards Commission is also quasi-judicial as well, and it, you know, if you're changing it, then maybe they should change it too, and I just don't know how that works, but that's just a comment.
If I may?
Yes, Tony?
Thank you, sir. Coming from the residential side, new to the commercial side now, no longer as a sub, but I did want to comment because I had the experience last month on the residential side, now this month. I'd like to make a suggestion to consider this. First of all, the work sessions are not part of public record, so they usually aren't involved in any kind of appeal. The work session is also accessible to the general public. They're welcome and invited to attend those as well. The other thing I want you to think about is the possibility of making this kind of a hybrid situation where we still have our regular work session at the regular time. But if it looks like we're running short on time, because I agree that there are times when our meetings do start later because of the work session. So why wouldn't we have, for example, consider having a work session, a standard work session, but if we're running short on time, then those cases where we were not able to have a work session before the meeting time, those cases would have this kind of format where we have a mini work session just before the hearing is heard in the chamber. So we could still have our discussion. People will feel more open because the feedback I got last month is a lot of people did not feel open to have discussions and ask questions. And yes, sometimes things are brought in from the work session into the hearing only because they can't be addressed in a work session. We're told that, hey, this is something that needs to be brought up to the applicant. That way it's clear, as opposed to a lot of people sitting during a hearing, twiddling their thumbs, waiting, you know, for a 10-minute discussion before a case, which can happen before the actual case is heard. So what happens then is that we end up lengthening the amount of time people are waiting for their case to be heard. So I'm proposing that we consider a hybrid format where we still have our standard work session for running short on time, then do the work session for those cases that we didn't get to during the regular work session time. That's it.
Any other comments? Mr. Hoppy?
So I think a lot of times, for me personally, we'll have the work session and then we'll see another case and we'll see something that may be applicable for another case, something that is like, oh, well, that would be a good question. I think a lot of times having a little bit of a buffer between the two to be able to bring additional questions up to the applicant or whatever, because you may think about something later on. It's like, why didn't I think about that? Well, we should have asked this or we should have asked that. When it may come to a new, to a different case, we should have asked that to that applicant that we had 3 cases ago or whatever, as far as that's concerned. So my preference is to either, attempt to do what Mr. Perez has recommended, a small work session prior to, okay, and then have an additional, I know we're doing double duty there, as far as that's concerned.
Yeah, it's a legal, for B, it is a legal concern. Like, I'll be honest with you, this is my sixth city. You all are the only, and again, Fort Worth is different, right? But you all are the only city who does a Board of Adjustment hearing that way. But, you know, obviously, you know, you've been doing it that way.
That's because we're the best in the West.
You've been doing it that way, but, you know, definitely, you know, there's always room for improvement, you know, on both sides, right? So I'm definitely, you know, taking all these comments into consideration, for sure.
I will ask you this, if I may. Have there been legal challenges on
I'm not
appeals
aware of
on our
that,
Board of
sir,
Adjustment
right?
cases?
Yeah, what I would like to do, I don't want to get into a debate right now. You know, I'm not going to do that at this point. But like I said, I'm going to take all of your comments into consideration. And then we want to try for one more meeting and then see how we can adjust, you know, to meet some of your concerns. Oh, yeah.
This is, I fully support this trial. I think it's making it very relative to the facts at the time. I guess my only question would be to legal is that staff presentation is more like, I'm comparing it to the work session, which is not really the public record.
So that's what I wanted to clarify. It is public record. Even our previous work sessions, when there's discussion, that's public record. One, because it's listed on the agenda. So since it's listed on the agenda itself, and you know, if there were minutes taken or if it's being recorded, if there was a request, then essentially it would be deemed public record. So any comments made during work session, again, since it's listed on the agenda, technically, I mean, I would be of the opinion that it's subject to an open meetings request and would have to be produced, specifically if there were handouts provided during a work session. And so I just wanted to make sure that everyone is clear that the work session is listed on the agenda. And so any things that are discussed, any comments made, if it's recorded or minutes are taken, then they would be subject to the Open Meetings Act and potentially, you know, if it's appealed and there were comments made during work session that may have persuaded the board members in one way or the other, and then not communicated during the public hearing and the public wasn't aware of that, then it does pose a challenge to the board as into whether or not the process or the hearing itself was fair when you know, those same comments that were made during work session weren't made during the public hearing. And so I just wanted to make sure that everyone is aware that, and that's why I've advised boards since I've taken this senior position that work session really is intended for the staff to provide information to the commission. And if the commission has technical questions as it relates to the application, then those questions should be asked in work session, furthermore, as well as in the public hearing. If there's any personal views or if there's any neighborhood association views, I would ask that you reserve those conversations for the public hearing for the applicant to be able to either rebut those concerns or whatnot. And so I think that was kind of our conversation with Ms. Stringfellow as to why it would make sense to have just a staff report done, kind of the format. UDC does this format as well as DDRB, as well as I think that, and I think that's it. But I think there is more discussion as into whether or not, just as Ms. Stringfellow said, moving towards kind of that type of presentation. So I just want to make sure that that's clear on the record that potentially what is said during work session or what is said in work session, it's not off the record. It is on the record and open to the public. It's subject to an open meetings request.
Is it submissible in court?
You could potentially be subpoenaed if you had made statements and someone in the public was there, and then essentially you could be asked as a witness to testify to what you stated in work session if it is different or than what you said in the public hearing, or if you fail to share it, but may have been deemed as something that would have tainted the pool when it comes to a decision-making. So
I'll
In the
continue.
history of the Fort Worth Board of Adjustment, has this ever happened once? Has this ever been an issue?
I've only been advising the board, so I would have to confirm that discussion, but that is always something that we communicate to all the boards.
Thank you.
I will note for the record that my tenure on the Board of Adjustment has been almost 11 years now, and to my knowledge, that of the relatively few times that we have been taken to court, that items in the work session have not been brought up.
I continue to support us continuing this for one more month, hash it out, see where we are. I don't think we need to throw the baby out with the bathwater. But then we can reevaluate after our third time through.
I have one more question. I mean, I really still don't even understand the format of how that all happens. I guess staff comment, or staff presentation, we still have open discussion before the public hearing starts?
Yes, yes.
And that's what I was trying to do today, is as a staff presentation, we could ask and things, and then I made sure that I'm ready for the public hearing.
Okay.
Yes, that's
Okay.
why at the end of my comments, I asked if there were any questions of the board, to also give you the opportunity to ask anything that would be clarifying, if there were any technical issues that you wanted pointed out, to give you opportunity to do that.
Okay, that makes sense.
Thank you for the staff presentation. With that, I see no other business. Oh, I'm sorry, Kay.
So I just want to say I'm all in on the changes that have been made, because I have been concerned about the open meetings effect of that work session, because we're not voting on minutes for that session, and we don't have recordings. But I also really, really like that we have a staff presentation now for each case before the applicant has to speak, because I think that's more fair. These applicants that come in, many of them do this and that's their job, but some of them, it's not their job. They're just trying to save their own business. So I like having the staff saying these are the issues and pointing out why they're here to us first, so we have that. And I would encourage the staff to, like, as you go on, get even more and more like touch points where we on the board can go, okay, first we're going to hear this part and this part and this part, so that because we are only here once a month, so we kind of know what to listen for, because we've heard it in that sort of format before. That's my only input.
One of the things I will say for my presentation is that typically I try to walk through the issues as they are presented on the staff report, instead of jumping around back and forth. And so that it's in a more linear fashion, so that if you were reading the staff report as I was going along, you'd be like, oh, okay, that's where I see where this comment ties in with the staff report, and this is where it's tying in on the map, and those sorts of things, so that it is very consistent if you've reviewed the docket already, what to expect.
Any other comments?
Ms. Freed?
Ms. Freed?
Yes, I also think that it's a good thing to continue trying, because I think that having everything open to the public is much cleaner, and the public knows everything that we're hearing and all the questions that we ask. My only concern is that that meetings could get quite long. So if we have the flexibility to say start at 9 instead of 10, if we've got a full docket, I think that's important. While I appreciate and respect the desire to have a consistent start time, I don't know if that's always possible, because our the size of our agenda varies so significantly from time to time. But in general, I'm in favor of the new format and really appreciate that staff is continuously looking for ways to improve our process. So thank you.
Anyone else? Any other matters of business? And I ask for a motion to adjourn.
Oh, you can just adjourn the meeting yourself. You have a-
Lance, do it. Thank you.